Good morning, everybody, and welcome to our webinar on the impact of environmental factors in an expropriation. This is the first webinar being presented by the Aaron-Burles Expropriations Industry Group, but it's the first in what we plan on being a series of webinars. So before we get started, I just want to advise you to keep your eye out for further webinars on the topic of expropriations. And if there's anybody out there with some burning topics in mind, we encourage our listeners to suggest topics for future discussions. My name is David Nalligan, and I'm an associate with the Municipal and Land Use Planning Group here at Aaron-Burles and member of the Expropriations Industry Group. And I'm joined for today's conversation by David Atlin, Senior Vice President at Altus Group, and Scott Stoll, partner in our litigation group and also member of our Expropriations Industry Group. Both David and Scott are well versed in these topics and well known amongst their peers, so I'm not going to waste any time with lengthy introductions. So I thought, why don't we just get right to it? So when we sent out the invitation to this, we identified a number of discussion topics that are up on the screen in front of you. We don't propose for this webinar to go through a formal presentation on each of these topics step by step, but rather what we thought is we'd present a discussion, a conversation, and we hope that we hit on these topics before you. If we miss out on some, we might loop back at the end, but we hope that through our sort of organic discussion, we can cover off most of these topics. We've also, for the purpose of the discussion, created some discussion scenarios that we'll walk through, and where appropriate, we've tried to highlight some of the relevant case law. And importantly, too, when we send out our invitation, we asked people to submit questions in advance so that we could sort of tailor the discussion based on the interests of the listeners. And happy to report that there are 271 registrants for this webinar. So hopefully most of your questions can get addressed. So I propose that we actually start with one of the questions that we received prior to this webinar. And that question came from Dominic Tadino in the city of Mississauga. And he asks, once an expropriation has commenced, what's the legal authority for an expropriating authority to enter onto lands to conduct environmental testing if the owner does not consent? So starting off with a very legal question, I want to turn the answer over to our legal expert, Scott. I'm wondering, Scott, could you comment on this?
Okay, thanks, David, and good morning, everyone. And this will be one of the things that we're not going to talk too much about, but the expropriation can occur under different acts and authority. So we're focusing on Ontario, and we'll spend most of the time talking about the Expropriations Act and what we see as typical, which involves municipalities. So in this specific scenario, when you're looking to gain access, Section 10 sub 3 of the Expropriation Act provides the ability of the authority to make application to the board to authorize entry, and it basically says on such terms and conditions as may be specified. So therefore you need to think carefully about what you're going to request and also understand why you're requesting it so that you can get the order you need and want in that situation. There's a couple cases that we've mentioned in the slides, and so those would give you some extra reading around that. So it becomes really important when you are thinking about these things to talk to your environmental consultant about where you're going to be testing, why, what sort of needs you actually have so you can describe them in your application. We also wanted to just provide an indication of some of the other situations in language, and I do a bunch of work in the energy industry where we're looking at linear facilities like transmission lines or pipelines, those types of things. And the OEB Act basically has a similar type provision where people are have obtained the leave to construct and are starting the expropriation process. So it's 98 sub 1 and on the next slide over it's 98 1.1. And again, basically the board can order such surveys and examinations as are necessary for fixing the site for the work. So this can go beyond the environmental aspect and hit those tangential items like archaeological studies and geotechnical surveys. So you want to understand the full suite of what you're doing and what you're going to need to do on each property so that you can frame your request to the board appropriately and get onto the site and do the required testing so you can not only follow through on the offers and the evaluations, but also understand the technical limitations of what the site conditions are actually going to mean for your project. So and so I think that covers that. The OEB, one of the better examples of where that was applied was the Bruce to Milton line, and the board had basically given an order that was fairly broad to allow the environmental testing to occur.
Thanks, Scott. And I think it's important to note that it's incumbent on both the authority and the claimant to act reasonably when faced with a request for access. And we saw that come up actually recently in the Windsor case, Windsor versus Shergar, which I think a lot of our listeners will be familiar with. It's the recent case where the board determined that the claimant was not entitled to interest and not entitled to his costs. And one of the reasons they identified as why they found the claimant acted unreasonably was that for 18 years they prevented the authority from entering onto the land to conduct environmental testing.
Right. And I think that's one of the themes that will come out of this conversation is that reasonable people will make the system work, and I think reasonable people have made the current shortcomings in the processes that we're going to discuss work in most cases. So there hasn't been a lot of decisions actually go for adjudication, and because people have kind of come to a realization at the end of the day that it's better to get a deal in the certainty where you can make it work. So
great.
All
well,
right.
Why don't we get right into the meat and potatoes of the Expropriations Act? And I know, David, you've been anxious to talk about how we determine market value. So why don't we take a look at the definition of market value under the Act, and maybe you can provide your comment.
The definition is provided on the slide you see. Good morning, I should have started with. The appraisal presumes a sale, and an appraisal is at an effective date. So market value is, as stated, willing buyer, willing seller, no undue stimulus, and that can be in conflict in this context, as we'll get into, with people who had no intentions of selling their property because they have contamination, and their contamination was going to take time to deal with in an efficient manner. And I think that's where this conversation will go with some of the conflicts that we see in people dealing with contamination and expropriation values.
So 14 sub 1 defines market value, but then there's some sort of limitations put on to it in 14 sub 4. I wonder if you have any comments about that?
Well, this is where appraisers and lawyers spend a great deal of time in section is 14.4b, where it reads any increase or decrease in value of the land resulting from the development or the imminence of the development in respect of which the expropriation is made, or from any expropriation or imminent prospect of expropriation, is to be ignored. So by having the expropriation of environment trigger an environmental response is contrary in some regards, or argued to be contrary in some regards, to the market value, which you have to assume what would you do at that date that it's sold, because on the date that it's sold, you might be taking it into account. People are disputing which provision should get the emphasis.
Yeah, and I think that's where part of this goes is which policy takes precedent in which circumstance. And so how do you deal with this? And as you can see from the language, it's not really clear that this situation was contemplated when this was drafted, and what policy should take precedent.
Precisely. And we'll get into some examples later on, but sometimes doing nothing with contamination is your best bet.
Right.
But
And
a sale might force you to deal with it.
Yeah, we have a number of industrial clients that have historic contamination issues, but there's no obligation to do anything with those right now. So basically, in that situation, time is their friend. So
Exactly.
And speaking of timing, then, we also have provisions under the Expropriations Act on the election date for compensation. And David, how does that election date affect the decision or the timing for remediation?
Well, it just closes a circle on what I was saying earlier, that the owner of the land has lost the opportunity to determine when they will sell or when they will respond to the contamination on their property, if ever. Now, this is brought into a time frame that was not necessarily in accordance with their needs, plans, wishes, requirements.
Well, and in a situation that is kind of tangential, what happens if it's your neighbor that contaminated your property and you didn't know about it? It all of a sudden starts triggering actual knowledge and limitation periods. So what do? Are you forced to deal with your neighbor right away? So it creates a number of potential scenarios, and we're going to try and not spin this too far out of control with all the variations and combinations, but just a quick reference to that. So
we did joke about subtitling this expropriations webinar, "How to Make Your Head Spin." So we'll try to avoid that as much as we can. But why don't we start taking a look at some of the scenarios that David's brought forward so we can really flesh out some of these ideas.
Okay.
So up on the slide, David has presented a scenario with a partial taking. And David, why don't you walk us through what's happening on this slide?
It's the four scenarios are just very simple illustrations for conversation. So in slide one, we have a piece of land that's development land. It's fairly immediate development land. It has contamination. I don't think there's any dispute that market value, whether you take into account 14.4b or not, will have to have a response to the contamination. If you're going to develop, you have to remediate, risk assess. Certainly there's something to be done. The questions that arise here, though, are, will the widening be remediated at exactly the same time in cooperation with the rest of the site, or is there a marginal different cost to do the road widening in isolation? And is there a distinction between the standards to be remediated to, between the use of the expropriating authority and the use of the developer?
Yeah.
I said residential development, could have been commercial industrial by illustration, when then we have potentially different standards.
And that's maybe a good place to put a little background on the environmental. When you're looking at cleanup, there are different ways you can clean up land, either what we would call a dig and dump, and removing it, or there's a risk assessment where you can leave contamination there. And there are several different standards, and sometimes it's not entirely clear which standard is the applicable standard until you go talk to what the regulator would consider appropriate. Had some different discussions where which table applies when you're looking at the contamination. Also, we have generational aspects. We have existing records of site conditions which say that the land is sufficiently clean for certain purposes, but there's still contamination on it. So
Scott, when do these discussions or contemplations take place? Should it happen before the notice of expropriation comes out, or is it really a response to the assessment that's provided when an offer for compensation is made?
Well, I think it's all. There's going to be a number of different conversations that take place, but I think early on, if you're the expropriating authority, you're going to be looking at the tabletop exercise, right, through the phase ones and the review of what your project is to see which lands are impacted. And then you're going to try and assess where the contamination occurs or not, and assuming you get access, that only gives you part of the information because, as David's saying, we don't know what the intention for the property is. So you have some information, but you don't have the context to have the principled discussion. If there's an open dialogue between the landowner and the authority, great. If not, then you're left making certain assumptions. And this becomes important in the discussion is having a consistent philosophical approach to the assumptions you're making. You can't cherry pick a couple of assumptions here and then have mutually inconsistent assumptions on the second part of it and hope to have a principled negotiation and resolution. But without the owner's intent, it becomes very difficult to understand where their mindset is at and how to do the proper analysis. So, I don't know if you have anything more to add on that, David.
Well, it goes, that ties in very nicely actually with the next slide, scenario 2. Because in scenario 2, we have exactly the same diagram as scenario 1, but now we're saying development may not be for 10 or 20 years. And we know that that's a long time, so there's the obvious issues that we talked about before, but now we're layering onto it. The owner's intent may have been not to do anything for 10 years or 20 years because a type of contamination may actually dissipate or the cost is of such significance that they'd rather spend the money in 10 or 20 years.
Exactly. If you go back to that imminence of development, in theory, you can envision a situation where if you're going to have the remediation being done on site, is there some sort of savings that can occur to the aggregate of the authority and the landowner by having one person deal with it all at once?
Yeah, but when?
When
is the question?
Yeah, and if it's imminent and the timing works, great. If not, you get into this scenario, and that is a whole new complexity.
And this is the point of the two scenarios. So in here, the authority is now going to have to deal with the contamination within the acquisition, within the widening. How do they prevent and who's responsible for the prevention of contamination flowing from the original property into it once that's done? Who's responsible?
Right.
What about the difference in cost on a per unit basis, per square foot, per cubic foot, whatever it is, to deal with the contamination within the widening as compared to the entirety, and when?
Right.
You have two different responses now that could be in conflict.
Well, exactly, and you can add a couple of other issues on, and I think one of the things that, like from the environmental perspective, you're trying to look at the incremental impact of the contamination. In Toronto, there's a lot of very deep excavations done for the buildings, and so there's going to be the removal of soil. The fact that an element of that soil may be contaminated provides an incremental cost, not an underlying cost for just getting rid of the soil, but because it's contaminated soil. So there has to be a pretty nuanced look at what costs are really the costs around the contamination. It's not just hauling away soil, if that was going to be done.
So 14.4b says you ignore the expropriation and the valuation for market value. I think everybody essentially agrees with that principle. So we'll have a different environmental response and value as compared to what the authority will have to face in dealing with the remediation at that date.
Yeah.
Is that difference accepted by the marketplace? Does everybody understand that the owner will have his valuation of an unaffected land reduced by an amount less than the authority is going to face in responding to the environment, plus the authority's potential responsibility to prevent further migration? You could have a divergence in costs that are substantial.
Well, yeah, exactly, depending on the nature, and I know we said no contamination, but depending on the nature of the contaminants you're looking at, the use, and the underlying land values, you can end up in very different scenarios and mindsets and impacts. So,
and the whole issue of having to put up a barrier of some nature is very expensive, especially if it's on a temporary basis, but 10 years still temporary time.
Right, but some of the barriers you end up with some ongoing treatment facilities, and you can't unknow what's there. So some of the things, once you know, you have to deal with them. Right.
So this is just a conflict in my mind between the intentions of the Act on 14.4b and the reality of a market value at a point in time where you would address something sooner than you would have intended at a different price point than you might have intended.
Right. And you look at it, you have 10 to 20 years, well, that's a big time range, right? Mm-hmm. If you're even going to consider looking at something in that sort of time, is your contamination dissipating over that period of time just through natural attenuation? What sort of time value are you going to assign to any of these cleanup costs and stuff?
And is there not also a risk that the cost might increase as the property values go up?
And standards change.
Standards change. Knowledge changes. The highest and best use can change.
Right.
The market could change. You could shift. You could go from low-density residential to high-density residential, as we see today in so many locations.
Right. Yeah. So, and this makes the analysis very difficult to do. And I think for staff that are looking after this is probably going to make their heads hurt in how do they come up with a logical position to, like, formulate a plan, formulate a budget that's reasonable when you don't have all the information.
That's right.
It also might require competing budgets for how the environmental impact affects the acquisition prices, and a budget for the environmental impact for the actual development, which is the purpose of the expropriation.
Right.
You may have two different budgets.
Yeah.
Interesting.
Yeah. So depending on how you're set up, you can end up having money and obligations under two different groups.
Right.
So at least two different groups.
So why don't we take a look then at the third scenario where we're actually switching things up a little bit.
So the third scenario actually fits in with something that Scott said a little bit earlier. Here we have an industrial building that's already gone through its environmental response. You've got a record of site condition. There is contamination. An industrial building can continue on unabated. There's absolutely no reason for the owner to respond. There's nothing to do. There may or may not be an overall impact on the value of the property depending on the market and the circumstances. Maybe there's a little bit of a stigma, maybe there isn't. Regardless, the owner can run along unabated. But in fairness to the authority, some of the land that they're requiring is contaminated, and they may not be in a position to accept contaminated land.
Yeah, that's one of the questions that's going to require some serious discussion. The typical approach for municipalities or expropriating authorities is they want clean property. What that means for each one may be a little bit malleable. Whether they will say, okay, well, it's been risk assessed, it's acceptable for residential development. There's still some contamination there. Mm-hmm. Will we live with that? And I think, like, the easy answer is to say we want pristine soil. That may be a very expensive solution. And
in this instance, to make the land pristine in the area of the acquisition will have no impact on the value of the overall asset or the remainder asset. So there's no betterment that's going to be enjoyed by the property owner.
Right.
Yet, at the effective date of appraisal, the transaction is land that is contaminated.
Right.
So this scenario actually fits in nicely with one of the questions that was posed by one of our listeners before the start of the webinar, and that's a question from Jacqueline Chan, solicitor at the City of Markham. And she asked whether there were any cases where an authority has given a discount for environmental contamination where the highest and best use was the existing use. In other words, where the property is not a development site that would require a record of site condition. And I think that's what we've got in this scenario. We've got the highest and best use being the existing industrial use. And is it right for an authority to seek a discount for environmental contamination?
This is going to be part of the issue is how costly is the contamination in relation. I'm not aware of a specific case that, or is there one on this?
You know what, we have a case with the opposite, and that's
With the
that's the Simone Group Properties versus City of Toronto. I'll just quickly put the
we can jump
slide
over
up.
to that.
So in this situation, the City of Toronto attempted to impose a discount for environmental remediation, but all the experts around the table agreed that the highest and best use was the existing use and that there was no
Right.
need to remediate. And the board agreed and did not allow for environmental
Right.
remediation, which was then affirmed by the divisional court as well.
Which is kind of the flip side. But it goes back to, I guess, you look at almost two scenarios, like from a practical purpose, do you look at really two scenarios? One where you're looking at the existing use and doing a complete analysis on the impact there, or where there's a different highest and best use, and look at that, and then say what's a commercially reasonable response from either party's perspective, depending on where your number is, right? Like the landowner is going to be expected to act in a commercially reasonable manner to maximize the value of their land, their business. So
I agree with that. I also want to make the point that just because you don't have to respond to remediation right away doesn't mean that there's no impact on value because of the contamination. So it might be unfair to ignore it altogether, regardless of what the case is. That doesn't mean that the impact on value is the cost to remediate a risk assess.
right,
But there still may be a market response to the contamination being in place.
right. And again, this goes back, although the current highest and best use, but maybe like the current industrial use for that specific owner. But
So highest and best use is assumedly an objective test. The use
Right.
has to be legal, or probably would be legal.
Right.
Which will contemplate a rezoning. Has to be physically capable, and the contamination and the response to contamination could have a significant bearing on that because of the cost to achieve, because that bleeds into the financial test, which is the third test. The last test, maximally productive, is just a fancy way of saying you have multiple choices for highest and best use. The one that makes the most money wins.
right,
But the environmental response is inextricably linked to the highest and best use, because it can be too expensive sometimes to remediate to what would otherwise be the highest and best use. We live in our bubble here in Toronto where land values are so high people will pay astronomical amounts. But you take the same environmental issue in a smaller community and it can be unaffordable
right.
to do that work. You do change the highest and best use.
Right, and you've seen that notion on the environmental side where getting rid of soil, like actual removal, was going to basically sterilize land because it was just so expensive, which is why we ended up with risk assessment and other incentive mechanisms to allow the development of land to make it more economic for the municipality, for the public and society, to allow these things to occur. So,
For those with a little bit of history, I recall early in my career the Tehran project and the environmental impacts down there, and it was a serious issue about how the land should be dealt with from a development perspective, yet you had an environmental overlay that was quite significant and serious.
so
The world's evolved and matured since then, but we haven't solved this dilemma.
I think legislation is often playing catch up to the real world problems that are being experienced, and I'm not sure that any government's going to be elected on a burning desire to update the Expropriation Act as a plank in their plan. So this is one of those things that people might acknowledge needs to be done, and then you're looking at some of the things being done now, but I think it's very intermittent that you'll have those sort of discussions take place.
I agree. My clients who earn 6% a year are very happy with that.
Yeah, I think a lot of people would take 6% annual return for now.
If we go to the last slide, because it's completely different. So scenario 4 is here because it makes us think completely differently, and that is the property itself is impacted by contamination, but the actual area of the acquisition by the authority is not.
Yeah, and this kind of touches on one of the things. Does the remainder property that has contamination become economically developable? If you ignore any sort of, if they have to clean it up over the smaller 18-acre size, has the cost per acre been driven up so much that the landowner can't do anything?
So we're really now into the shades of gray. One could argue that there's an injurious affection to the remainder lands because you've gone from, in this construct, $200,000 per acre for remediation to $278,000 per acre. So is it simply a matter of $5 million, does $5 million go away? Is it no, you've got an extra $78,000 cost? Or does that go so far as what Scott has said, is that that extra $78,000 per acre of cost no longer makes my highest and best use commercial, but I need to come to another highest and best use, or arguably I've lost my development opportunities for the foreseeable future. There's a full analysis, but what's the responsibility of the authority who isn't touching contamination, isn't taking away any contamination, isn't impacting it in any fashion?
Right, and this is where the public policy of why should taxpayers be on the hook for those additional impacts opposite the impact on the private interest of the individual landowner, who is basically seen through no choice of his own, his land taken, and his ability to do it what he wanted with that land, which he had a legal right to do before the expropriation, directly impacted.
Or is the thought of an expropriation of things of that nature, are those simple risks? You know, sometimes you win and sometimes you lose on market risk. Is this type of a response just a market risk that the owner had all along?
I don't know. Yeah, I don't know. I don't know that there's good direction on that. And I guess this maybe becomes a case where the owner and his advisors really need to think carefully about how do you maximize what's left, right, in the aggregate when you're talking to the authority. How creative can you be in your discussions?
This might be a good time to jump to one of the questions that just came forward. John Davies has asked, is the owner not entitled to the full value to him or her? The requirements of the authority should not be considered. And maybe this touches a little bit on the purpose of the Expropriations Act, which is, to make the expropriating or the claimant whole and to compensate him fully for what's being taken.
So John, as an appraiser, very good appraiser, thinks as I do, 14.4b, no increase or decrease in value, and therefore the intention of the expropriating authority ought to be ignored. And I'm comfortable with that position that he's put forward. But a point-in-time appraisal will necessarily have to take into account unless the parties agree to assume it away. And I know that there are authorities who are not willing to assume away their costs that they have to immediately face.
Yeah, and that becomes a problem, right? When you have very different risk tolerances or approaches to these things, how do you reconcile them? And this where you can get stuck in a very difficult conflict, because the authority has their perspective and their obligations to follow through, and the landowner has their very real property rights. So
who bears the onus then of showing that a discount for environmental remediation is reasonable or appropriate?
Pardon me, David. Sorry, I didn't hear.
Who bears the onus of showing that this that a discount or a reduction in price is reasonable. I would assume it's on the authority.
I would think both.
Yeah.
I would think both parties should attempt to impact the pricing fairly in accordance to how the market would respond to it as at the effective date. And according to 14.4b, it's the response as if the authority hasn't shown up to the party.
Right. But, so I think from a practical perspective, like, you can argue legalities that the authority has the obligation, but at some point, the landowner has an equal and opposite obligation to put their perspective on the table. And so I agree with you. I think in reality is you got to have both the evidence of both parties. If you're going to litigate it, there needs to be both parties bringing the evidence to establish their perspective on how the numbers actually work.
But that's assuming that we get to litigation or arbitration.
Right.
But in practice, when an authority provides an appraisal report, when it makes a Section 25 offer or through a Section 30 agreement, do they include a justification in those appraisals on any environmental discount? And in your experience, is that full enough?
And typically, they don't, and that's not a criticism. There's a very narrow window between the time an expropriation process begins and the reports are delivered. And anybody with experience in environmental work knows that that window probably isn't adequate to come up with the proper answer for how the environmental response will be and what the cost will be. It's a very difficult position for authorities to be put in, to have a complete answer
Right.
so early.
Right, exactly. So does that appraisal then really become the opening of a dialogue under a certain set of assumptions, which the property owner is going to try and rebut the assumption?
Well, most appraisal reports have standard language that says
Exactly.
we ignore environmental concern. But I think it would be very helpful if even at that level, everybody acknowledged that there is an environmental concern that has to be addressed.
Right.
So that everybody knows that the valuations being dealt with aren't the final number, it's not the final place, and maybe you can coordinate the work because you put sinkholes in, or you put monitoring holes in, or you take samples, and then you have competing samples and who has access when. That just drags it out.
Yeah, it's good for the environmental consultants and the lawyers in those situations where but it's not very good for either of the clients.
No.
So, and this is where you want to keep as reasonable an approach as possible from both parties, and also keep the dialogue opening. So you can comply with the statute and what you need to do, but I think there's a way in carrying out that where you can create an atmosphere where you can create a settlement on value at the end of the day.
Yeah. And back to your point about starting the discussions before the timelines of the Expropriations Act or whatever other act you're under start to kick in.
And that works when you know in advance.
Right.
But sometimes you simply don't know.
Right.
Owners, for reasons that you mentioned earlier, Scott, for generational issues or prior owner use, you're as surprised as everybody as an owner that there's a problem, and now you've been alerted to a number of other responsibilities that you may have to yourself.
Right. If you're sitting there and you own a property that's down gradient from a dry cleaner that was there 20 years ago or 30 years ago and is not there now, you can all of a sudden find some contamination. You could be down gradient of a gas station. There's a number of different scenarios like that. And so you end up all of a sudden living with the impact of something that you had no responsibility for. So what are you going to do? And again, this goes back to it can get very complicated very quickly, because if but for the expropriation, I discovered contamination on my property because I was doing due diligence for refinancing, then all of a sudden I have knowledge. I would have to see whether I would pursue that against the neighboring party who caused the contamination. Well, what if they're not there, right? A lot of these things have historical beginnings, And even if they are there, do you have an ability to enforce? Like going through those claims on an environmental side becomes expensive, time-consuming, and you need somebody on the other end who can actually pay at the end of the day. So you may have a right without a remedy in reality.
And you may now have, as you mentioned earlier, a limitation to respond, and you wouldn't have had that clock ticking
Right.
but for the authority coming along to do whatever work
Yeah.
that they deem necessary.
Do you have the wherewithal to pursue that claim now that it's been triggered? Right?
Right.
If you're in a startup business and this comes along and like cash is tight, do you have the ability to pursue your legal rights? And but if you're well established, well heeled, it's a different scenario from the landowner's perspective over what they can do. So
And ability to pay really doesn't bear on the appraisal. The
No.
appraisal is supposed to be an objective exercise,
exactly.
not value to the owner.
Right. So from the authority standpoint, they would say, not our problem. And I have a lot of sympathy for that. So
Well, they didn't cause the contamination, but their discovering it
Right.
has a cascading effect that may have other unintended consequences.
Yeah, I mean, the claimant might have been quite happy just to continue along in life not knowing what was in the soil.
Well, yeah, there's a lot of situations where the people can just progress along in their daily lives, either blissfully unaware or basically saying, I don't need to open that can of worms right now. I don't need to go investigating that.
There are many properties that are contaminated, known and unknown to the owners, where there's absolutely no reason to respond to the contamination for their ongoing use.
Right. If you go back to that industrial site in scenario 3, and there are a lot of brownfields and industrial properties that people know are likely contaminated, but there's no reason or impetus to do anything.
If we go to, you're right, in scenario 2, which was our development site, there's absolutely no reason to respond to that contamination until such time as you're ready to begin your development.
Right.
And the response then will be based on the rules in place then, the contamination then, your highest and best use then.
Right.
But now it's going to get measured against a different set of standards, the standards today.
Right.
A highest and best use estimate today and knowledge today. And those could be
Yeah.
very different things, both to the positive and the negative.
Well, yeah, this is the problem. It can swing both directions. And I think that's one of the things that people have to be aware of, and was part of the cherry-picking comment I made earlier, is you have to be willing to accept the bad and the good if you're going to maintain the integrity in your approach from the authority standpoint. So,
And all landowners accept risk, hoping that the reward is greater. So some landowners accepted that contamination risk if they knew about it.
Yeah.
Possible they wouldn't have known about this contamination at all because they haven't done their environmental investigations yet because they're not ready to develop yet. So this might be a whole new world of knowledge for the owner.
yeah, it could be the new world, or they could have bought it at a discount, at an extreme discount because it was contaminated when they acquired the property. So they've already factored in that.
Which would make it fair to factor in on the acquisition for that part. It's
Right.
just the question as to factoring in the same as the market would have appreciated for the whole property versus the part. And I'll go back to John Davies' comment, 14.4b, don't take it into account. But I'm not sure authorities ignore, in all cases, that because they still have to deal with it immediately. And the appraisal is the value at that day.
Yeah, no, I agree. Like that timing issue becomes real for the authority. They can't avoid that.
That's right.
Okay.
So we've got an act that doesn't really provide a whole lot of guidance, and we've got more questions than answers the more we talk about this. So it's somewhat surprising to me that we don't actually have a lot of case law that discusses, how do we interpret this and how do we apply these principles. We still often rely on the 1992 case of Masai versus Toronto for the principle that, yes, environmental factors should be considered when taking into account market value, and there should be a reduction where that takes place. But that's a 25-year-old case.
Yeah, and things have moved on in some ways. If you look at the change in environmental law, like there used to be a comparison between the actual remediation cost, and in general, you're looking, like in environmental law, you're looking at the environmental problem in totality. These issues are often looking at the environmental issue in a partial circumstance. But the evolution on the environmental side is you would look at either the cost to remediate or the reduction in value to the property, and say, like, if it was going to cost me $100,000 to remediate, but the reduction in property value is only $25,000, then are you unjustly enriched if you force the remediation at the $100,000? So there used to be that very real argument, and the courts recently, in the last 3 or 4 years, have really pushed to the property owner being entitled to the clean land. So I think you're still going to see some evolution. I think the pendulum will swing a little bit, but that sort of diminution in value is kind of taking a real back seat on the environmental side.
That's right, and we saw that in the case of Toronto versus Bernardo, where the highest and best use was determined to be $242,000, but the remediation cost was even greater than that.
Yeah.
And so the City of Toronto offered compensation of $1, and the board upheld that.
Yeah,
that finding.
which is interesting, right? Because if there's no obligation to deal with the contamination, should you change that? It's an interesting issue, and I posed the question to David: is when you're looking at when it's a partial taking, would any of these issues ever switch it over where what made the most sense was a full taking? And I suppose you can see that in some scenarios as a possibility, probably a rare possibility, but still something that could be out there. But
I'll just comment on this, Bernard. I don't know the case, but let's say to sell the property at the date of appraisal, as determined by the Expropriation Act, that's the correct answer, that the remediation costs exceed the unimpaired market value. And whoever owned that property was making $25,000 a year of net income and had absolutely no motivation to sell, no reason to sell, no reason to clean. So the valuation answer may be absolutely correct, and the poor owner has lost $25,000 a year of net income. Mm-hmm. And that's hard to reconcile for many people.
Right. And I think that's the fairness of the result is what a lot of people look at as well. How can that be fair? How can the state come in and adversely impact that individual in that way? Because but for the expropriation, they would have been able to carry on making their $25,000 every year.
But the market value is absolutely correctly dealt with in this, because nobody would buy it.
So is that then better dealt with through sort of a business loss analysis or disturbance damages, or is he out of luck?
Well, it depends. I don't know the circumstance of that case. I don't know how you come to the $242,000 first, but without that income, you may not have had a value of $242,000. It's just an area where we have conflict. I mean, I have in my own mind answers to some of these questions, but there are conflicts. People have different views. We just got a supplementary question to our number 4, whether or not what we've been talking about is what's referred to as a before and after approach to the valuation. That is, what's the value of the land before, what's it valued afterwards, and the value comes down because of the higher cost of contamination response per acre. And that's exactly what it is. That's what we talked about before. Right. But before and after simply brings together both the market value and injurious affection. Our conversation earlier tried to separate those two concepts for the purpose of the conversation.
Exactly. It was more illustrative of that scenario. So,
we also just got a question in, sort of a timely question. How does the elimination of the Ontario Municipal Board affect appeals? And as most people online are aware, Bill 139 is in force and effect, and we're expecting proclamation April 3rd, which will sort of continue the Ontario Municipal Board as the local planning appeals tribunal. So, Scott, I don't know if you want to comment. From my understanding, there's not any significant changes to the Expropriations Act other than housekeeping revisions to refer to the new tribunal rather than the Ontario Municipal Board.
Yeah, my understanding is that the proposed new rules will basically deal with the expropriation procedure, but I don't think it's really going to be that substantive.
Right.
I see it more of reshuffling the same cards a little bit and not dealing with some of the fundamental issues that we've been talking about here. So
one interesting change that may impact expropriation appeals is changes to the OMB Act, which is now the LPAT Act. Under the old OMB Act, the OMB could sort of step in the shoes of a superior court and employ some of the rules of civil procedure, specifically with respect to summary judgment motions and things like that. And I don't think the new LPAT will have those same court-like powers.
That's my understanding, and it'll be interesting to see if that evolves fairly quickly. And I think that's going to be an interesting situation to keep an eye on, to see whether there's a few fact patterns that would really cry out for the need for those types of powers to exist.
Right.
So,
okay. So I think we covered a lot of what we hope to cover in our topics, but we have some additional questions and discussion up on the slide now. Dave or Scott, if you see anything up there that you think that we need to address further.
From my concern, and I'm more on the environmental side, you end up trying to understand what the environmental situation is, and remediation and risk assessment can result in very different responses and obligations on the owner. So I think you have to understand in what circumstance it becomes appropriate to choose one path or the other. And the expropriating authority, they're looking on the remediation of what they're right. Very few would want a risk-assessed property. There might be a few circumstances where it happens, and I can think of a couple, but it's pretty rare.
And that goes to the point that the economic response very appropriately may be very different. And so if you take 14.4b in a very orthodox fashion, the response by the authority is not relevant.
Right.
It's only the response that was appropriate in the open market absent the scheme.
Right.
And so then you have a different cost and a different reaction to the same piece of land and the same.
Right.
And that's fine. That's an acceptable solution if everybody bought into it and agreed to it up front.
Right. Yeah, and that's the question, will everybody buy into it?
Exactly.
But yeah, and the cost consequences are very different for the landowner, so.
They can be. I'm also very alert to your comments earlier, Scott, that we didn't put into slides about all the other things that can be responded to where you are removing only part of a plume. So they have an interim cost not to prevent contamination from traveling.
Right.
Whose responsibility is that?
Exactly, and if certain of the information become publicly known, what other obligations flow from that? So all of a sudden, You're seeing from the environmental side, the ministries are very concerned about vapor intrusion in buildings as a result of certain types of contamination. Well, and that can impact it through the health department and other places, so it can cause a significant amount of work.
Now, the risk of that information becoming available in the marketplace isn't limited just to an expropriation.
Yeah.
It could become aware through a normal sale, financing. So there are other ways. So I don't know a property owner gets a free pass on that risk, and every case is going to be looked at individually. But the expropriation certainly triggers it at that date.
Right. Yeah. I guess in legal terms, you shouldn't be rewarded for willful blindness. So, anyways.
Well, we only have about 5 minutes left, so I think I want to ask for sort of some concluding comments. But before I do, as lawyers or appraisers, as you know, we're often brought into these scenarios on the claimant side, at least, at sort of the last minute. Hey, I just got this notice of expropriation. I don't know what it means. They're discounting all of this money for environmental contamination. If you're in that position, either as a lawyer or as an appraiser, what are sort of the initial steps that you would advise your client?
Well, I think from one of the questions I would be asking up front, what other discussions have taken place? Because most of my clients just don't jump right to the expropriation. There have been lands agents out talking to people to understand what may or may not be expropriated, and that's where I'd like to get kind of a clearer picture of what's going on. But if this is really kind of come out of the blue for them, then I think you need to understand what the nature of the property is, and then start assembling some good advisors for some of the technical, the appraiser, and if there's an environmental concern, you'll need a person that'll be able to work with your team to understand what the impact is.
There's a lot of information that should not be at dispute. All appraisals are a combination of fact and opinion. Where the parties can figure out how common facts,
right,
it would also make life a lot easier. So it'd be nice to see a lot of cooperation on both sides and get those common facts.
Exactly.
That would help.
Yeah, it would. But that again goes back to reasonable people will make it work. So,
I agree.
Well, I want to thank you both for joining us for this discussion today. I think we might have made some heads spin, we might have made some heads hurt, and we definitely raised a lot of questions, but I hope we had some sort of useful guidance or answers to provide to everybody listening this morning. I just want to thank especially Jody Johnson for pulling all this together, and Shannon Corrigan, our articling student, for doing the research and pulling together the slides for us to put this webinar out to you this morning, and especially to the Arden Burles marketing team for all of their hard work in organizing and inviting and getting the technical acumen together to pull this off. So thank you very much for that. And I also want to remind everybody out there to keep your ears open for future webinar discussions. And if you do have any ideas or thoughts on what you'd like to hear from us, please send those forward. Also, thank you for sending in your questions. If we didn't get to your questions and you still have some need for an answer, our contact information is up on the screen before you, and we'd be more than happy to answer questions if you send them to us by email. So with that said, thank you very much, everybody, and have a pleasant morning.